The President, please be seated. The chamber is now in session. For today's schedule, we will continue what we left off yesterday. That is the request for submission of additional documents to be put before this chamber by parties to the proceedings. We started that proceeding yesterday, but we had not finished it yet. And the international co-prosecutor submitted to adjourn the proceeding yesterday in order to prepare himself for the document to be submitted before this chamber. So I believe proper documents and proper list of documents with proper identification of those documents to be submitted before this chamber shall not be appropriate, and they shall not be lumped up together with no proper identification. They all should be well organized in advance. And the important thing is identification of those documents shall be properly mentioned, including the document numbers, the titles, as well as the year numbers of those documents. Because some documents have the same names, the difference might only be the date of the document. And you, the co-prosecutor, submitted those documents yesterday, but withdrew himself to make a new list on those documents. And actually, all parties have been reminded of this proceeding a few months ago. And now I would like to give the floor again to the co-prosecutors, so that they can provide clarification on the documents they wish to submit and consider put before this chamber.
Your Honours, may it please your court. Just in the beginning, to clarify your Honours' understanding of what happened yesterday. We just sought your leave because you were at the close of your afternoon session to respond in more detail to those very fundamental questions raised by Judge Laverne. So we had our answers, but we thought we would give them in detail this morning. Number two, Your Honours, the documents that we sought to discuss with my learned friends were on the basis of the observations of my learned friends. It was not on the basis of any confusion or any lack of understanding of those documents on the part of the Office of the Co-Prosecutors. Having said this, now I'll immediately go to the two questions raised by His Honour, Judge Laverne. And those two questions were this: do we have the French translation of the annex to the filing of the 29th of April 2009, which is E61, which comprises of the name, the description, the ERN number, and all such details that Your Honour just mentioned that are required for putting a document before this chamber. The second question Judge Laverne put to me was what does the co-prosecutor have to say in respect of the annotations of the accused on the documents that we mentioned in our filing of the 19th of August 2009, which comprises annexes C and D of that filing. I shall address these questions in seriatim, and I would request Your Honours to indulge me for about 5 to 7 minutes because I'll have to give a little background about these documents. The documents pertaining to the armed conflict have been on record of this court since at least the 29th of April 2009. Under 2.2, Article 2.2 of the Pactus Directions on the filing of documents, a party, such as the co-prosecutors, are required to file documents in 2 official languages of the court. The co-prosecutors did this on the 29th of April 2009. We checked once again with the CMS. The practice thereafter is for the receiving judicial authority to forward that filed document in the 3rd language of the court, should it wish to. So I would most sincerely request Your Honours to clarify with the greffiers whether it's actually been forwarded for translation into French. The other question that arose was in respect of how many documents as attachments to that filing of 29th of April 2009 are in English, how many are in French, how many in Khmer, and how many in more than 1 languages. And I'll take essentially 2 minutes to respond to that question. There are 430 documents that provide a chronological account of the protracted violence between Cambodia and Vietnam. Each document provides evidence of armed clashes or disputes on different dates and on different locations. These documents emanate from international and national sources, including minutes of the Standing Committee of the CPK and other organs of the Communist Party of Kampuchea. And they are supporting and corroborative of the statements made by the accused, by the expert Nayan Chanda, and others in this case. I shall now just tell you the translation status of these documents. All these documents have been on the case file for at least 1 year and 5 months as of today. Of the 430 documents, 212 were included in the introductory submission filed on the 18th of July 2007. They have been there for more than 2.5 years. 135 of these documents were referred in the closing order of the co-investigating judges of the 8th of August 2008. Combined, 239 out of these 430 were included or referred to either in one of those filings. The remaining 191 documents were disclosed on 21st of March 2008 in document D60, which was entitled Co-Prosecutors Request to Admit Documents Relating to Proving the Existence of an Armed Conflict During the Period of Democratic Kampuchea. Now, just to tell Your Honours about requirements of translations of these documents, and I shall be done with in about 2 minutes on this issue. My learned friend and the counsel for the charged person, Q. Sampan, took exactly the same issue in case file 2, that they don't have all these documents in the French language. As a result, the counsel for Q. Sampan said the trial should be stopped, and my learned friend said expeditiously all these documents to be translated. The co-investigating judges, in a detailed and reasoned order of the 19th of June 2008, said this, and they both belong to civil law jurisdictions. Accordingly, a charged person is entitled to the translation into Khmer of indictment of the co-investigating judges and elements of proof on which any of this indictment is based. The charged person is also entitled to the translation into Khmer of the introductory submission and the final submission of the co-prosecutors and their footnotes. And last, most importantly, what the learned investigating judges observed, the remaining translation of the case file documents are not elements of proof for the determination of the trial chamber and are not therefore covered by the requirements to translate into the languages of the charged person. Now, this was confirmed by the pre-trial chamber, in which the pre-trial chamber observed that exculpatory material should also be translated A, into the language of the accused, B, also in the other language so that the counsel can assist the accused. We agree with that. This is not exculpatory material. And the last and the most important thing the co-investigating judges held and confirmed by the pre-trial chamber, for the rest of the documents, the counsel should rely on the multilingual facilities available in the defense team as also available in the defense support section. And they said the same applies to other parties, including the Office of the Co-Prosecutors. In our most respectful submission, we have abided by the conditions of appropriate representation, appropriate identification as required by you in the two languages that we were supposed to file them in. And we did that on the 29th of April 2009. My learned friend's client, he understands at least French and Khmer. My learned friend's national colleague understands French and Khmer. My learned friend understands English and French. And I think in line with the order of the learned investigating judges, we are not required to translate every single document on the case file. And indeed, that supports the establishment of armed conflict into all the three languages of this court. Your Honours, the next issue raised by Judge Laverne was on the question of the statements of the accused. Now, my learned friend said in response to the question raised by the civil parties that this is not an occasion to reopen the trial. This is not the occasion to reopen the evidence. Clearly, we are not asking for that. What we are asking for, Your Honours, is essentially in line with what Your Honours directed. Your Honours, in your transcript of the 31st of August 2008 directed, and which is about 17 days ago, this chamber on today and yesterday shall consider procedural matters such as putting documents before the chamber under Rule 87. We are doing exactly that. We have given the notice of these documents to my learned friend on the 19th of August. In any case, all these documents have been on the case file since the time the introductory submission was filed in July of 2007. They are all in Khmer, which the counsel's client understands, and they are, in our most respectful submission, not required to be put to a witness. They are to be essentially put to the accused, not even examined in open court. He should just give his remarks in those documents which have been appropriately identified so that Your Honours may take a decision on that matter. Now, in respect of documents that have already been put in this trial, I clarified yesterday, and for better record, I shall do so in exactly 1 minute. When we filed our annexes C and D of the filing of 19th of August in respect of the accused's annotations, we were aware that some documents have been put on record. We went through entire transcripts of Your Honours till the 19th of August and excluded such documents that had been granted E3 status. So to directly respond to His Honour Judge Laverne's question, such documents that have been granted E3 status have been excluded. Now, such documents that may have been mentioned But Your Honours have chosen not yet to grant an E3 status, clearly have been retained in that list so as to assist Your Honours to take a decision and to assist the accused in responding to those attachments in Annexes C and D of the filing of the 19th of August. That's my clarification. I don't know whether I've been very clear, but should His Honour has any further question, I shall be able to answer that. And just to finish, these are the most direct evidence. And I ask myself the question, if the accused's annotation about what he did in S21 are not retained on record, what better evidence would this court have in the absence of major witnesses, in the absence of people who saw and died, and in the absence of in the presence of this gap of 30 years when witnesses' memories have faded and some have chosen not to give a complete version for fear of self-incrimination? In our most respectful submission, this is the most direct, relevant evidence that proves the case of the guilt of this accused, which he has accepted. Now, it's international law that no conviction can be returned only on the guilty plea of an accused. And that's what we are doing. We are not wasting the time of this court. We are just telling Your Honours to put these documents, which he may have authored, because there are at least 60 of them, to confirm that he did or he did not do, without any taking of time of this court, and Your Honours may conclude that what he is actually admitting is reflected on the factual record. This will also assist to keep a complete historic record, because after all, you are not just a criminal court, you're also recording the history of what happened in democratic Cambodia. That's my submission, and I shall be available for any questions.
De faire un travail d'histoire pour savoir ce qui s'est passé exactement sous le régime. Voilà ce que
pour que les choses soient parfaitement claires.
In order for things to be perfectly clear, are we to understand that at present there is no request for translation into French of the summary of the elements that were suggested for putting before the court?
Was that question to me, Your Honour? There is no request from the office of the co-prosecutor, because the judicial chambers make that request once they receive in the two languages of the filing of the parties.
A last question, perhaps, with regard to the proposal made by the defense of obtaining a one-page French language summary. Do the co-prosecutors have a final position with regard to that request?
Your Honours, I undertook that I shall do so. It's happening, and it will be given in all the three languages of the court in, Your Honours, I can't give you the number of hours, but very soon, within hours.
The President, Mr. Francois Roux, you may now proceed.
Thank you, Mr. President. Good morning to you and to the other members of the bench. Well, so it took the Office of the Co-Prosecutors 15 minutes to give a yes or no answer to the initial question of Judge Lavergne, which is the documents which you transmitted on 29 April, have they been or have they not been translated? 15 minutes to answer that, in order that at the end of the day what we heard was that it was no, they haven't been translated. Judge Lavergne, you invited the defense yesterday to be in contact with the Office of the Co-Prosecutors in order to find a solution, and I told you I wouldn't do that anymore. And today you have confirmation that it's absolutely useless. Therefore, you have been submerged, overwhelmed, I would say. We have in our office the carton of documents which was addressed to us concerning armed conflict. I won't return to the debate we had about armed conflict. We are overwhelmed with documents, and I said since the month of January, in all discussions that we had then with the Office of the Prosecutors, that I would accept that 200 press excerpts not be translated because it would be too much time, but I want a one-page summary in the French language. Since January, I fail to understand. I don't understand this method of work. Second, I am terrified, and I mean what I say. I am terrified to see coming to the light of day at the end of trial. How can I characterize this to avoid being offensive? I'm terrified. Dear colleague of the Co-Prosecutor's Office, apart from all due respect, I'm terrified to learn that at a time when the trial is nearly over, you, the Office of the Co-Prosecutors, you realize that you still haven't put before the court 60 confessions, that you have not yet asked for adversarial debate before this court of 60 confessions. Is this what you are confessing to us today? We've just spent 6 months with you. You've brought witnesses to be heard. You submitted documents, and at the end of the day you tell us, wait a minute, there are 60 confessions here which we hadn't yet mentioned. So I wanted to hand them to you in bulk, as we would say, but when the trial is over, when do you expect the accused to respond? So you are going with 2 months remaining, while I thought that we were going to be pleading immediately after the debates. We were given an extra 2 months. What for? So that you could write another 160 pages of memorial that you might be studying. And what do you want to do then? Make sure that the accused will have to answer all these questions, all these documents which you're dumping in bulk before the court? I'm shocked. I'm shocked that you could be so irresponsible and poorly organized. to avoid using stronger words. So I apologize for becoming angry over this, but there are elementary rights of the accused. Elementary rights. 1 year of investigation. 8 months of trial. A trial during which it was the task of the Office of the Co-Prosecutors to bring into the debate these 64 documents and to obtain a response from the accused. You chose not to do this. You chose to make us waste time with useless witnesses, but you cannot deprive the accused of the right to make his observations orally and in adversarial fashion about these documents. It doesn't seem to me that it is possible to reopen the proceedings in order to do this, or then let us make everything clear. The chamber would need to immediately release the accused, and then we'll start the proceedings again for an entire year. And I would like to remind you that the accused has been in detention for 10 years, that every passing day is an additional day of provisional detention. One cannot play around with this. So, it's very simple. The defense considers that the proceedings and the pleadings are over, that the prosecutors cannot file over 60 documents, and then in passing they say Annexes C and D. I only have an Annex D. I want to avoid any mistakes. Where is your Annex C? I don't have it. What is all this about? And at E152.3, all that I have is an Annex D. So what do you mean when you mention an Annex C? Thus, Mr. President, members of the court, on behalf of the defense, I ask that all of these documents not be accepted because they were not the object of adversarial debate during the proceedings. In the alternative, if the court decides to authorize that these documents be put before the chamber, I ask that the entire proceedings be reopened and that the accused be immediately released.
President, the International Co-Prosecutor, you may proceed.
Your Honours may indulge me just for 5 minutes. I shall not be long and I shall not use strong language. My learned friend should just go back to the filing of the 19th of August 2009 to see that Annex C is the Khmer translation of the Annex D that you have before you. Number one. Number two, Your Honours, as Your Honours yourself declared on the 31st of August 2008, your proceedings are not over. You have kept these few days and you have been very generous with your time allocation on this for allowing the parties to put documents before you such as to complete the record before you when you sit to deliberate your judgment. Now, all these documents have been on the case file. We did not invite my learned friend to give his response in a public hearing today or yesterday. We made our filing on the 19th of August 2009. My learned friend from then till today had 1 month to respond to this and in writing. And he knew on the 31st of August that Your Honours are putting these 3 or 4 days apart only to receive the response and not to give a response in court that he will not respond. Now, if he were to not respond, that is fine. Your Honours may then decide. But my learned friend should not say that we are delaying after having filed the application about a month before because he did not choose to respond to that application. And the third and the most important submission in this regard, Your Honours, is this is usual practice in international tribunals when at the conclusion, especially of guilty pleas, evidence in support of what has been pleaded is accepted by the parties just for completion of record. And yesterday I saw a very laudable submission by my learned friend that these exhibits should be put on the website of this court. We sincerely support that. Because after all, if only Doik's guilty plea was to be put on the website of the court without any supporting independent documentation, it will not be seen as justice has been properly, judicially and legally done. Your Honours have led these proceedings. The witnesses that have been brought before this court have been asked to come by Your Honours. Any wastage ever sought by the Office of the Prosecutor would have been denied by Your Honours. To say in open court that the court's time has been wasted by useless witnesses called by court, in my most respectful submission, is inappropriate. And lastly, Your Honours have led these proceedings. This is an inquisitorial trial. Your Honours took 4 hours and the Office of the Co-Prosecutor took half an hour for a full day's hearing. We took 15 minutes for a half a day's hearing. Therefore, Your Honours, we, in discharge of our duty under 87(1) to prove the case beyond our reasonable doubt, most respectfully submit that these are the most directly relevant documents that could have been put had the trial been longer. And really, this trial shouldn't have been longer because, after all, he's accepting some guilt. Therefore, for a proper historical record and for completion of these proceedings and for you to make an appropriate judgment matching his guilty plea with the documents on record, it will be in the interest of justice that these documents are accepted, and I shall say no more. Thank you.
The President, Mr. Francois Roux, you may now proceed.
Mr. President, I can accept that reproaches be made to the defense provided it deserves it. There are rules, and the rules, my dear colleague, are valid for all parties. And I would like to remind you that the directive provides that I need answer either within 5 days or within 15 days of the French translation of your request. Your 29 August request remains to be translated into French. All of the documents that were conveyed to me have not yet been translated into French. How do you expect me to respond? And you've indicated that you yourselves are in possession of these documents since the beginning of the proceedings. Would you mind explaining to the Chamber why you waited until 29 August to file your request, or to submit your request, correction? These documents are documents that you said you had spotted from the beginning of the case. You knew that you were going to use them, and you waited until 29 August. 29 August to submit them to the Chamber. How do you expect translation services to operate? So, when I receive your request in French, I will then have 5 or 15 days to respond, and I'm still waiting for your request in French.
President, Mr. Co-Prosecutor, could you please conclude your response, and we should wrap up this issue now, because yesterday we experienced the same discussion, and that today's topic is not much different from what we already indicated yesterday. So could you please conclude this submission, and that if the Defense Council wishes to finish to respond, then it would be the final response?
I think Your Honor read my mind. I just wanted to rise to say that I don't want to say anything. I just want to correct my learned friend that it is not the 29th of August, and he can read that document, it is the 19th of August. I shall say no more.
The President, judges of the bench, would you wish to make any observation in relation to this matter? We now would like to give the floor to the Defense Council to clarify on their submission to put a document, and the Chamber would like to know whether the Defense Council is still intending to put this document before the court.
Donc, merci, Monsieur le Président.
Thank you, Mr. President.
La défense avait déposé donc
The defense
un certain nombre
team
de
had
documents
submitted a certain number of documents to the co-investigating judges under reference D80.
Et la défense souhaite
And the defense
que maintenant ces documents
would like that these documents now be considered as having been put before the chamber.
je les cite par ordre.
I will list the order for you. D80/1,
Le livre
the book Pol Pot, Anatomy of a Nightmare
Philippe Short,
by Philip Short,
qui existe en français
which
et
exists
en anglais,
in French
qui est déjà
and in English, and which is already
versé au dossier des
filed because it was filed with the
à la
investigating
code D80
judges.
fraction 2,
At D80/2,
le livre de David Chandler
we find the book of David Chandler
sur S21
about S21
en français et en anglais.
in French and in English.
À la cote D80
Under D80/4,
le livre de François Bizot
the book by François Bizot, which we mentioned during the proceedings, which is called Le Portail, the Gateway.
à la cote
At
D80/5,
D80/5,
le livre de Monsieur Raoul
the
Marc
book of
Génard,
Mr. Raoul Marc Génard,
nous avons également parlé à l'audience,
which we already discussed during the proceedings, Les Clés du Cambodge.
à la cote D80/de
Under
fraction,
D80/6,
le livre de François Ponchot,
the book of François Ponchot,
année 0,
Cambodge, année 0,
dans son édition française,
in the French and in the Khmer versions.
dans le même bordereau de pièces,
In the same
nous
list
avions déposé
of exhibits which we had also filed with the investigating judges
nous avions visé à la cote D88
under
des
D88.
cartes provenant de
We
DCCAM,
had entered maps originating from DC CAM
D80
under D80/9, satellite images originating with DCCAM, and under D80/10, more maps concerning the mass graves of Cambodia, and it is a DCCAM document. And I would like to specify that these last three documents and principles have already been put before the Chamber when Mr. Raoul Macgenard was heard by this court. Then we asked to be allowed to file new documents, which are at E5/9, and that was from the outset of the proceedings. That is, and these are, for one, the book of Henry King, our witness who was unable to appear since he passed away in the meantime, the book of Henry King, called in English The Two Worlds of Albert Speer. In this regard, I would like to recall that we asked that be submitted. I believe it's already in the case file, but I'll check it. I would ask that the letter in the form of an affidavit, the letter of Mr. Harry King, be filed in lieu of the testimony which he has been unable to give and which is found under E5/9/2. In this list, E5/9 asks leave to put before the court the transcripts of the hearing of 30 October 2003 of the International Criminal Tribunal of the former Yugoslavia, containing the pleadings of the prosecutor versus Abramovich. Also, the video recording of that hearing, or at least excerpts of it. Also, the judgment handed down by the International Criminal Tribunal for the former Yugoslavia on 10 December 2003 in the Obrenović case. I would like to specify the fact that it is a tradition that one need not communicate jurisprudential decisions, but we did that out of a concern for transparency. And lastly, in this E5/9 list, we asked that be put before the court the book of Desmond Tutu, which was mentioned during the proceedings the other day, in its French and in its English versions. Of course, the defense wants to add to all of these documents, or at least verify, that the admission of the facts be put before the chamber. Normally it's been the case, but I do not have any number for that document. I would like that this be verified. We've mentioned this admission of the facts at length, and I would be grateful if the registrars could verify that this admission of the facts is indeed has indeed been put before the court. And lastly, as we said yesterday, one document which is a last-minute document. That is the interview given by Mr. Choumet, one of the civil parties, to a French magazine. It is one page long, and we have communicated a French version and a Khmer version to our learned opponents. As indicated, we did not wish to submit this document prior to having been allowed to show the video passages which were shown yesterday. These are the documents that the defense wishes to be included in the documents put before the court. I also imagine that the consultation of Mr. Raoul Génard under D80 must have been put before the court. Correction, D82, but we will need to verify this as well. That is all, Mr. President.
The President, Judge Laverne, you take the floor.
Oui, merci, Monsieur le Président.
Judge Laverne, thank you, Mr. President.
La Chambre a rappelé à toutes les parties.
The Chamber reminded the parties recently that with regard to putting documents before the court, the Chamber would like to know the reasons why these documents should be put before the court. This refers particularly to the books. Some of them have already been put before the court, others not yet. The defense should provide us with some reasons why it wishes to put some of these books, some of which are fairly voluminous, before the court. And the defense should also indicate why it wishes to put the other documents before the court. Mr. Roux, Your Honor, of course all the documents we have discussed in the proceedings, in particular during the hearing of witnesses. I am thinking in particular of Mr. Chandler's book, Mr. Bizot's book, and Mr. Raoul Marc Génard's book. I imagine that there will be no difficulty with these works because they were used to support the testimony of people who were called to testify in court. Concerning Desmond Tutu's book, we discussed it with one of the witnesses. This book contains material that the defense intends to rely on. One of the witnesses was questioned with this book, using this book. It doesn't appear to pose a difficulty, in my view. We did not talk about two works, that is Cambodia Année Zero, written by François Ponchot, and Pol Pot, Anatomy of a Nightmare. The defense intends to delve into these works to support its pleadings. It is not the entire books that the defense will use, but the defense will refer to certain passages in the books, and I must say, in particular, Philip Short's extremely well-referenced book. The defense had considered calling Mr. Philip Short as a witness, but in order not to extend the proceedings, it decided not to do so, especially as it considered that the book having been put before the co-investigating judges, it would be sufficient just to refer to some of its passages. That is what I have to say in regard to the books. I do not think that the other documents require particular comment. This applies to jurisprudence. It is obvious that nothing can prevent the defense from relying on jurisprudence, and projecting a video or video footage of a hearing rather than reading transcripts. It will be much better to view the footage, which will be presented in my closing remarks. I'd like to make the point now. Judge Lavergne, just to shed light on this for the benefit of the chamber, so this is not new material being put before the chamber. This is not new evidence. What we are interested in is the evidence. You say that you intend to rely on this material to illustrate, to support your case. So this is not evidence, in fact. What is it if it is not evidence? Because if it is evidence, we've got to know exactly what we're talking about. Mr. Hu, I thought it was obvious. I'm sorry. You are right to raise the question. This is not new evidence. This is illustration of matters that have already been discussed in this chamber, which will rely, this illustration will rely on these works.
The President, the Chamber would like to give the floor to the co-prosecutors to make observations regarding the request by the Defense Counsel for the documents considered to be put before the Chamber, including those books as mentioned by the Defense Counsel. You take the floor.
And Your Honours, in the very beginning, I'll remind you that I shall be brief. My learned friend has the experience of being in this court for about 2.5 years. And we, in our filings, are cognizant of two words very particularly. One word, as Judge Lavergne pointed out, is evidence, and the other word is authorities in support of a submission made by a party in its pleadings. Those authorities can be filed, they are taken on the case file, but they are not treated as evidence. In our most respectful submission, Rule 87, 2 and 3 pertains to evidence and not authorities. Now, my learned friend, in one argument of about 10 to 15 minutes, has, and to use his words, dumped more than 1,000 pages of documents onto this court without even filing a small motion justifying, as Judge Lavergne said, the reasons for filing these books. Now, clearly, the prosecution will not have a disagreement regarding books of Chandler, Bizot, because they were heard as witnesses. And we would most respectfully agree to acceptance of those books as being put before you. But it's nowhere reflected on record that you, the learned defense counsel, ever asked for Philip Short to be brought before court. You didn't ask. To our awareness, the investigating judges, neither did you ask this court. The reason why we asked Nick Dunlap's book to be placed on the record of this court was because we had asked for him, and your honors in your wisdom did not approve of it. And yet that book was discussed, and therefore we felt it should be before you when it comes to consideration of evidence. Therefore, we would respectfully submit that Philip Short's book be not taken on record. We would submit that David Chandler's book, and he clarified at the end of his testimony that the authoritative version is the English version, be taken on record, albeit along with its French version. We also submit that Jenner's book, although very tangentially relevant to the facts about S-21, may be taken on record. We submit that Francois Ponchot's book be not taken on record because it does not add to anything that your honors have not held, and therefore it shall be barred under 87(3)(a) as being repetitious. In respect of maps of DC cam, satellite images, and more maps, my learned friend may have referred to them, but the defense never extensively put these maps and documents on the record of this court or exhaustively discussed them in the proceedings, either before the investigating judges or before this honorable court. We don't know the relevance of these maps or the idea that my learned friend wishes to advance through the use of those maps. But because simply being maps, and because we are at the end of the trial, we shall not get into this argument and would accept or leave it to your honors to decide on the question of maps. In respect of Henry King's statement, now clearly Henry King was a distinguished prosecutor of Nuremberg. He wrote a letter to my learned friend, which my learned friend sought to read, and your honors quite appropriately disallowed it. We would respectfully submit that that letter be taken on record because it's a reflection of a very senior Nuremberg prosecutor. However, your honors may consider keeping only one page of his book on record, which he mentioned in his letter. And that page, or 2 pages, pertain to Albert Speer, and my learned friend mentioned that. In our respectful submission, admitting the entire book, which is available in our awareness only in English, or I may be wrong, it may be available in French, would be inappropriate, and therefore your honors may consider accepting only that page of that book. Also, in respect of Henry King's letter, your honors may also wish to direct my learned friend for completion of record to place his letter to Henry King, on the basis of which Henry King replied, and which would have found the basis of his testimony before this court, which could not happen. Howsoever relevant transcripts and videos and judgments of the Obrenović decision may be for the case of my learned friend, in our respectful submission, they remain legal authorities. They are not evidence. They were not put to any witness. They were not put to any expert. If your honors were to put into the evidence all the judicial authorities that you have referred to, we shall run into thousands, if not millions, of pages. So we would respectfully submit, your honors may leave it open to my learned friend to use such legal authorities in his closing submission, or any of his pleadings that it is open to him to file, but not consider as put before the chamber. In respect of the book of Desmond Tutu, once again a very distinguished figure, president of the Truth and Reconciliation Commission of South Africa, the learned national and the international co-prosecutor had made a concession, and I would stand by that concession, and I shall add no more. In the end comes the statement of Chu Mei. Now, my learned friend gave me a long lecture of how things should have been done by the Office of the Co-Prosecutor and why we should have been more organized and be able to come before you ahead of time. Now, this alleged journalistic statement taken by Paris Match, which to my recollection is not a serious intellectual academic magazine, of 26th of November 2008, exactly about 10 months ago, when this person is a civil party, when this person deposed before you, and when this statement is only a journalistic version of what he may or may not have told this journalist, would not add to anything that your honors may wish to consider at judgment. Therefore, although it could be read by my learned friend in his closing submission, but its admission or its being put before the chamber should be denied. And I hope I have been brief. Thank you very much.
The President, the Civil Party Council, do you have any observations to make regarding the request by the Defense Council? Hong Kum Soon. Thank you, Mr. President. Good morning, Your Honors, distinguished members of the Court. I am Hong Kum Soon, representing Group 2 and 4 of the civil parties. And I would like to provide my following observations regarding the request by the Defense Council. I agree with what has been said by the international co-prosecutor because there are several books requested by the Defense Council and they are in the English language only, and it is inaccessible for us, the National Council for the Civil Party. Regarding Chum Mei's statement, at the beginning of the trial proceedings, discussions have been made regarding the agreed facts. I can recall that the Defense Council strongly objected any interview or statement between Kang Kech Yew and journalist, the UN representative who interviewed him in Battambang before his detention. And the chamber, especially Your Honor President, and agreed to his objection, and those documents were not admitted. Also, regarding the photographs and the videos made by the Vietnamese soldiers were sternly objected by the Defense Council, and the evidence were not admitted by the chamber. Regarding the final set of documents requested by the Defense Council, that is Chum Mei's interview with the Mary Smith from the 20th to the 28th of August 2008. I recall that on the 30th of May 2006, in June, correction, Chum Mei was a survivor and also a witness who came here to provide his testimony so that the chamber as well as parties to the proceedings, including the defense counsel, to question him. And the question is, why at that time, that is from the 20th to the 28th of August 2008 until the 30th of June 2009, the defense counsel did not question him on that interview so that the parties would have the opportunity to question or to verify those interviews. So this is rather a trick used by the defense counsel, and I sternly object the request for submission of this document made by the defense counsel. That is all, Mr. President. Thank you. The President, Alain Berner, you take the floor.
Monsieur le Président,
Mr. Werner, Mr. President, Your Honours, good morning. Just to say, Group 1 supports what has been said, and in particular with regard to Chumei. If this document were to be admitted as evidence, then Chumei should be called, should be recalled, because this is elementary. The least we can expect is that Chum may be afforded the opportunity to express himself with regard to what he may or may not have said to Parimatch. If the document is to be accepted, Chum should be called, and he should be able to tell us whether he said or did not say what this journalist recorded. It would be an elementary precaution to ask Chumei what he thought about this. Thank you.
Bonjour, Monsieur le Président.
Ms. Martino, thank you, Mr. President. Your Honours. Just a comment. If I remember correctly, when Desmond Tutu's book was mentioned, the defense counsel were asked to state the parties on which they intended to rely, the parts of the book on which they intended to rely. And it seems to me that Mr. Hu agreed to do so. If this is the case, then we would be glad to have the references.
The President, Francois Roux, would you be able to respond to the question posed by the civil party lawyer Group 3?
Mr. Hu, Mr. President, I did promise to provide a translation of the passages that I intend to rely on in my closing submissions. Since we have 2 months to prepare, you will have it, as I usually provide it, before my oral submission.
Merci.
Ms. Martino, thank you, Mr. President.
The President, judges of the bench, do you have any comments to make or any verification to make regarding all these requests? If not, let me move on. There are still civil party council to put their request. The President, Defense Council, Francois Roux, I notice you're on the feed. And before we move on to the next proceeding, I actually asked if there are any comments to be made by various parties to proceedings. But anyway, Francois Roux, you can take the floor, and please consider the time for our proceedings and make your comments precise. And also you should raise any new matters and do not repeat on the matters which have already been discussed. Otherwise, we would be here forever. And it would be difficult for us to make any decision if things go round in circle.
Mr. Roux. Thank you, Mr. President. I just wish to be afforded the opportunity to respond to what was said by the co-prosecutors and the civil parties in respect to the applications I made. The prosecutor was given the opportunity to respond to me in regard to their own documents. So I would like to respond to their observations regarding my documents. Very briefly, to reassure the civil party lawyers, I do not know whether Chumei's representative spoke on his behalf. If that is not the case, that might be a problem. The defense considered that it was not useful to disclose this document before the footage was viewed, and it was indicated that the footage would be shown during the interview of the accused with regard to his character. If this document is not agreeable to you, I have no problem with using it only in my pleadings. If you do not wish it to be included in the evidence, I will not use the document as such. I will refer to it, and this is my formal notice that I will use it during my pleadings. So there will not be reason to call Mr. Chumei again. In response to the prosecutor, as regards the books, particularly the book of Mr. Philip Short, I was surprised that you objected to this book being put before the court. If this is a problem for you, all right. I will use it in my pleadings. I am free to put what arguments I wish to put before the court, up till the end. If I offer to put documents before the court, it is because I want you to know beforehand what I want to use. If you don't want to know, that's your problem. In any event, the Chamber is now aware of some of the material on which I will rely in my pleadings, and the Chamber will decide to consider these documents as having been put before the court, or to consider them as arguments raised in the pleadings. I leave it to the wisdom of the Chamber.
The President, it is now appropriate for a break. We will take 20 minutes break, And we shall return at 20 to 11. The hearing is now adjourned. All rise, says the greffier. The President, please be seated. The chamber is now back in session. The chamber would like now to give the floor to the Civil Party Council Group 2 and 4 to have their submissions on the additional documents if they wish to do so. That includes both the remaining or pending documents which have not yet been put before the chamber. Hong Kom Soon. Thank you, Mr. President, distinguished members of the court. With the President's leave, I would like to clarify on a matter before the break. If I am not mistaken, the Defense Council accepted the objections raised regarding Chum Mei's statement and that it should be replaced by a video clip. The President, Councillor Francois Roux, can you clarify this matter, please? Do you understand the question raised by Councillor Hong Kom Soon? Thank you.
I said yesterday afternoon and this morning that yesterday we showed the video of the reenactment of S-21. I said that in that video we can see Mr. Chumei speaking. I said that we did not wish to submit the interview of Mr. Chumei prior to showing this court the video of the reenactment in S-21, and that this was the reason why the interview of Mr. Chumei was submitted only yesterday at the end of the afternoon, because the video of the reenactment was played only in the morning, and because Judge Cartwright had said that that video would only be shown when the character of the accused would be scrutinized. Is that clear?
Hong Kom Soon, thank you, Mr. President. I am now clear. Now I would like to talk about the request that we will put before the chamber for remaining documents or new documents. For Civil Party Group 2 and 4, we do not have any new additional document. However, regarding the existing documents, which we actually submitted between the 27th of April 2009 to the 10th of September 2009, in which, when the President would make reliance on those documents in your judgment, I would like to request for admission of a document in Khmer with the EAN 00369908 2003637 2191, and in English 0037 2188 20037 2191. This document talks about the victim, who is a civil party, E2/32, and that this civil party was sexually raped by the S-21 guard. And I would like these documents to be relied upon in your judgment, Your Honor. Thank you. The President Defense Council, do you have any response to the request for document submission made by Civil Party Council Group 2 and 4?
Thank you, Mr. President. We're in the process of checking whether the document mentioned by my colleague is indeed, it's the affidavit, correct? Which was drafted and which you would like to have submitted before the chamber.
The President, Council Hong Kom Soon, can you provide proper identification of the document? What is the document's title? Hong Kom Soon. The title of the document is Request for Additional Submission by the Civil Party E2/32 into the case file, dated 18th August 2009. The President Kasavut, you take the floor. Kasavut, thank you, Mr. President. I understand that the additional complaint made by the civil party seems to refer to a new fact, because in the facts in the indictment did not include that fact in their complaint. So we, as the defense counsel for the accused, believe that if a guard sexually raped a medic and then the chairperson of that unit was not aware of the matter, then it would not be the responsibility of the chairperson. Because during the regime, if there was an evidence proving such, then the person would be beheaded or killed. Therefore, from the testimonies we have heard, only an interrogator sexually raped a victim. And during the investigation phase, the fact that a guard sexually raped a victim did not emerge, and we would strongly object to this newfound fact. The President. Next, I would like to give the floor to the Civil Party Council Group 3 for the opportunity to make submission of documents. Main key. Thank you, Mr. President, Your Honors. I am representing Civil Party Group 3. In relation to the submission of new document, we do not have any new documents for submission. However, the documents already placed in the case file, that is the civil party applications, have properly been placed in the case file already, including E139 dated 13 August 09 and E161 dated 28 August 2009 with its annex, and E164. So we do not have any new additional documents for submission. Thank you, Mr. President. The President, Civil Party Council, can you reiterate your position again regarding the documents you mentioned? Now we are hearing any request for additional documents to be considered put before the chamber, and you should provide us identification of those documents, either new document or documents or existing documents which have not yet been put before the chamber for discussion or questioning. So, in adhering to the proceedings, all evidence are considered as evidence of the case file when they are put before this chamber for adversarial questioning, and that the chamber would be able to examine and consider those evidence for its judgment. Due to the complexity and the extensive scope of the case and voluminous documents, some of the existing documents have not yet put before this chamber for questioning, and this is the opportunity for parties to the proceedings to request for those existing documents to be considered put before this chamber if there is no objection from any parties to the proceedings. Can you reiterate your position, or you do not have any submission, or you just restate the documents you already placed in the case file? Council, Mr. President, in fact, the documents that we already submitted are actually been placed or put before this chamber, and those are the civil party applications, and we do not have any new additional documents to be submitted. The President's Defense Counsel, do you have any observation regarding this clarification by the Civil Party Council Group 3?
Two sets of observations, Mr. President. We've received from the groups of civil parties additional documents which the Chamber had requested concerning the 24 civil parties which the defense had challenged. The position of the defense with regard to the additional documents we received is the following. We wish to rely on the wisdom of the Chamber, except for civil party E2/64, where Duke has explicitly recognized that that person was indeed detained in S21 after scrutiny of the document that was supplied. Apart from that, and in order to bring to a conclusion the issue of new documents that were submitted yesterday by my colleagues, Counsel Tisrina and Werner, documents which have allegedly been recently discovered at S21. The accused is in a position, should the Chamber wish it, is in a position to give you his position with regard to the substance of these documents, and then the defense will make all appropriate legal comments. Thus, if the Chamber so wishes, we can settle and conclude that discussion this morning.
The President, Civil Party Council Group 1, you take the floor.
Monsieur le Président, nous sommes reconnaissants.
Mr. President, we are grateful to the defense for that position, and indeed we think it would be adequate to have this discussion now, which changes nothing to the fact that we will be submitting a motion for translation, if nothing else. But if we were to have a brief discussion here and now, that would probably be the best possible solution. Thank you.
The President, the accused, do you have an observation regarding the request for submission of 18 documents by Civil Party Council Group 1? The accused, Mr. President, the 18 documents were sent to me and I have reviewed them all based on their forms and the serial number DSL, and the writing was that of Comrade Ho and its Ho signature as well. So I submit that these documents are I-21 documents. Regarding the legal side of the documents, I would give that responsibility to my counsel, Mr. President. The President, Defense Counsel, you may proceed. Counsel would thank you, Mr. President. Regarding this matter, I still maintained my position, which I stated yesterday. I strongly object the inclusion of these documents into the case file. The reason is that every document relevant to I-21 should have been put before this chamber through adversarial hearing or via the co-investigating charges during the investigation phase. And these documents have not yet put before the chamber for questioning, so I still maintain my position of objection. The President, International Defense Council, you take the floor.
Non, les choses sont claires.
Things are clear. Duke says these documents do indeed come from S21. So be it. But we say, on the other hand, that it is legally not possible to bring in documents of this kind at the last minute and introduce them into the debate. This is what we're challenging. And I add that I have little professional experience, only 37 years, but I would say that every time that I've seen documents submitted at the last minute in proceedings, every time without exception, it turned out that this was a totally useless exercise. So, yes, these documents certainly do come from S21. No, they should not be submitted to the court today. That's very clear.
The President, International Co-Prosecutor, do you have any new matter to be raised? I think if you wish to talk regarding the old matter, you should not stand on your feet. So if you wish to talk about the old matter, you would not be allowed to be on your feet. You can only speak when there is new matter that you wish to be brought before the attention of the chamber. You are reminded on this. Thank you.
I totally accept what Your Honours has just said. It's an old thing in a new form. Yesterday, in respect of these very documents, we had said that we don't take any position because their authenticity has not yet been tested. But now that the accused has admitted, we would strongly urge that they may be put before the chamber. That's all, Your Honour.
Mr. Alain Werner. Mr. President, let me be allowed a moment to repeat what we said. We have already said what we said yesterday, and we have nothing to add in respect of our position. Thank you.
The President, judges of the bench, do you have any comments to be made? It seems that there is no comments to be made by the judges of the bench. Mr. Alain Werner, I already reminded the parties to the proceedings. If you have any new matter to be raised, you can do so. This is the last stage of the proceeding for today. And the chamber has received more than sufficient information regarding all matters discussed yesterday and today. So if you have any new matter to be raised, you may proceed.
Thank you. Mr. President, let me speak in English because I have the motion I would like to talk about in English. It's just a very, very short request. It's going to take me literally 1 minute. On the 11th of May 2009, which is 4 months and a half, my group, Civil Party Lawyers Group 1, filed a motion which was a request that the trial chamber facilitate the disclosure of an OIOS report to the parties. And in this request, one of the things we were asking was for the chamber to invite the parties to make written submissions on the content of the OIOS report within 21 days of its receipt. Of course, if you were accepting to direct a formal request to the UN Secretary General for the provision of the OIOS report. my understanding, and we checked this morning again, is that no decision has been taken 4 months and a half later. And as you are aware, all the civil parties groups joined us in this motion. So it became a motion from all the civil parties groups. So I'm just asking your chamber, because as you understand, some of us are going to leave the country very soon and have other occupations, and we would just be grateful if you can give some indication on when you think you can or will release a decision on this motion. That will really help us to organize ourselves. That's my only request. Thank you.
President, thank you. Francois Roux, I notice you on your feet. You may proceed.
Mr. Roux, not on this subject, but before you adjourn, we would be grateful if the Chamber could inform us what time limit the parties will be allowed for their pleadings. Perhaps it would be useful if the Chamber could say something about that. Thank you.
រយៈពេលកំណត់ផ្ដល់ជូនភាគីនៅពេលធ្វើសេចក្តីសន្និដ្ឋានបញ្ចប់នេះសូមអរគុណ
The President, thank you for your question raised by Alain Wagner regarding the decision to be made on the request by the Civil Party Council for a copy of the report of OIOS. You are informed that we do not put the matter aside. We actually prepared a letter to be delivered to the Secretary General of the United Nations for all the matters raised in that report. The UN already provided through letters to the trial chamber through a second reminder that we sent to the UN. So we actually have enhanced 2 letters from the UN, and 2 weeks ago the chamber agreed to make a decision to be informed or notified to the parties to the proceedings. The draft has already been submitted and finalized, but we need to hold a meeting in order to harmonize the decision in the 3 official languages. So in due course, the decision will be delivered to parties to the proceedings, and it will be delivered before we announce the decision regarding our judgment. Otherwise, the justice and fairness would not be up to the standard that we expect. So this is for your information. And thank you, Mr. Francois Roux, for pressing your question regarding the time limit for pleading. And for the final written submission, in order to make it clear at this stage, the Chamber would like to know the position of the parties to the proceedings regarding the time limit. What would be the appropriate time limit for the final submissions? And the co-prosecutors' comments are sought first. So you can tell the Chamber your intention on the time limit, and the plan, the schedule would be from the 23rd to the 25th of November 2009.
Your Honor, since this was not on the agenda of today's hearing, I cannot most respectfully provide you a firm answer because I'll have to consult the co-prosecutors, but I undertake to do it in the course of today to your greffiers. Would that satisfy Your Honors?
The President, thank you for your comment. And the Civil Party Council, have you thought of the appropriate time for your final oral submission? And how have you arranged or made a decision on whether you should present your final oral submission individually, or it's a combination of all the civil party groups?
Your Honor, as you understand, not all the civil party lawyers are present today, and therefore I think we would need some time, maybe not too long, but some time to consult and come back again. We can do the same thing. We can come back to your greffier in a way or another with a common position, but we need to consult. It's difficult for us to give you any firm statement without consulting. Thank you.
The President and the Defense Counsel, how much time do you think you need for your final oral submission? You should also take into consideration the final oral submission, which includes the submission made by the accused. Gassavood, thank you, Mr. President. I personally would like to request 3 hours of your court time, and my international colleague would like to request 6 hours of the court time, Mr. President. So the total is 9 hours. The President, have you consulted with the accused yet? The total of 9 hours, does it also include the submission made by your client? Mr. President, my client wishes to make his separate submission, and he shall inform the President at a later stage. The President, François Roux, you may proceed.
Mr. Roux, I will share my time with Ms. Canizares, the other counsel. I am asking for 6 hours, and I will share those 6 hours with Ms. Canizares.
The President, we have now come to the conclusion of the proceeding for the parties to make submission on additional documents. The Chamber would like to inform the parties to the proceedings and the public that there will be no hearing this afternoon, and the Chamber will also not holding any proceeding next week. However, the Chamber will hold several meetings on the pending documents in order to make written decisions regarding various requests made by the parties to the proceedings, regarding yesterday's proceeding and this morning proceedings, including objections raised by various parties. If necessary, after our written decision has been made and notified, then the Chamber will make a new schedule to hold a hearing regarding that decision. Additionally, regarding the time allocation for each party's final oral submission, which the schedules have already been set to be conducted from the 23rd to the 25th of November 2009. The Chamber will notify it in writing to the parties to the proceeding in due course after the Chamber receives all the notifications by the various parties regarding the time allocation. And we hope that parties to the proceedings would provide information to the Chamber through the graphics in due course, so that we will be able to make our decision accordingly. That includes our decision on the appropriate time allocation for each party, or whether we can reschedule the date for the final oral submission. I would like to declare the adjournment to this morning's proceeding now. And if there is a need, the Chamber for holding another hearing, then you will be notified in due course. Security guard, take the accused back to the detention facility, and you will be notified if he needs to be presented before the Chamber. Graphic, all rise.
La greffière, mesdames et messieurs, veuillez vous lever.